You're watching the Law and Crime Network, folks. Aaron Keller along with you for the afternoon as we are in the midst of a double murder trial. By double, I say two defendants, not two victims. Quincinio Canada and Dewan Mulazam are on trial accused of shooting and killing a Marine named Jonathan Price. He was 26 and he was leaving a bar where he was celebrating his wife's birthday. His wife was also shot. She survived. Let's go back to the testimony. And we just heard from a witness on the stand in the case of a murder of a Marine. That witness was one of the victims in this case. Remember, there are a couple of different incidents that are getting all rolled together under the prosecution's theory of this case. One of the incidents was a robbery at a hotel where a number of people were robbed. Prosecutors think that the murder weapon that was eventually used to kill that 26-year-old Marine, Jonathan Price, was taken from that hotel during the robbery. As we wait for witnesses to switch out here, I want to bring in our afternoon guest. Law and Crime trial analyst Julie Rendelman is here. And Julie, you were talking to me earlier that you already have some issues with the evidence in this case, if I'm not mistaken.
Again, I don't want to get too far ahead of myself, but I think the first thing I did when I came in was ask if I'm missing something in terms of what the evidence is, because so far what I'm hearing is that the only evidence appears to be identification by the individuals in the initial robbery. Remember, there's a robbery spree, but what appears to be coming in as evidence is a robbery that occurs about 6 days before the murder, in which a gun is stolen, and that gun appears to be the murder weapon that was used to kill the victim in this case. And so my question is there more than simply the identification by one or more of the witnesses from the initial robbery? Because I think there's some issues with, we can discuss it further, but I think there's going to be some issues certainly to explore with regards to the identification of the defendants in this case.
Yeah, you know, I mean, the way the prosecution told the story in opening statements earlier today, it seemed pretty clear-cut, and of course that's always the case after you hear an opening, but I thought the defense attorney, at least one of the defense attorneys, because the other defense refused or asked to postpone, wait to give a full opening statement. Well, the defense attorney who did said, I thought, a few really key points here that raise some doubt in this case. Is it enough doubt to clear these two men, get an exoneration here, or at least her client? We'll have to wait and see. But, you know, raising good points. No DNA collection at the scene of one of the robberies. There's DNA underneath the victim's nails, but it doesn't match the DNA of the defendants in this case. So whose is it? You know, if there was this fight and there was any kind of a scratch, okay, whose DNA isn't? The police don't know. And the way that the identification was done through a photo array seemed that it's a darned if you do it this way, darned if you don't, because there was a digital removal of a facial tattoo. And, you know, the defense attacked the state and said, why did they do that?
Well,
but you're saying that there's a problem if they didn't do that.
Well, we have so much going on, so let's start with the DNA. So the DNA, we know that there's DNA recovered from the victim's fingernails, and that DNA does not match either of them. And so I think we have to go back.
Yeah, we have another witness taking the stand here, so let's go back. We're going to hold these thoughts. We'll get to them when we come back next time. Wow, some really interesting testimony there in this courtroom in Lexington, Kentucky. Again, this is a murder case involving a victim, 26-year-old Jonathan Price. He and his wife were attacked when they were leaving a bar to celebrate the wife's birthday. The wife was robbed. Jonathan Price, a U.S. Marine, stepped in to try to help his wife. He was shot, the bullet struck his heart, and he died there at the scene. The wife was also struck. She was shot in the leg. A difficult case here, Julie, and look, we're having a lot of issues with identification here because we were talking before that witness about what the prosecution actually has here, and what you have is what appears to be a racially charged identification that was prone to some pretty strong attack there on cross-examination.
I mean, I read basically what he says is when he looks at the photo array, if you call it a photo array, because it looks like it was one photo shown after the other, he says number 2 and number 5 look most like the individuals that came in to rob me. And so most like does not mean guilt beyond a reasonable doubt. Most like means maybe it's him. And so then what the next question is that she asks, well, if you see him in the courtroom and points him out, is that him? And so I guess my problem is can there be anything more suggestive than an individual who views a photo array, is not positive who the individual is,
and then they haul somebody in front of them.
Not just haul them in a courtroom where the witness knows that the two individuals are being held there for a potential murder case. I don't know how you can
with
get
a death
more
penalty attached
exactly.
to it.
How is that? How is there anything more suggestive
So
than that?
then he's more likely to play it.
Appalling.
To play it out, and those are strong words, and you don't use strong words unless you mean them. So to play the logical chain out here, he has incentive to sit and say, oh yeah, I think those are the guys who did this to me.
And just so we're clear, I'm not blaming him. It's basically built into the prosecutor, to the way they are allowing this case to come in. Inevitably, a person's going to assume that the person that's on trial is the person they identified. I mean, that's what makes something suggestive. I don't know if they've never heard of lineups in this state, or they just felt they didn't want to do it because they were so worried that if they did a lineup and did it fairly, they wouldn't get an identification that they wanted, and they wouldn't get to put these two individuals on trial for murder.
And it smelled to me almost like they didn't want to do a full in-person lineup, because, of course, when that happens, you have to have defense counsel present, and there are objections that can be lodged to that. In a photo array, you don't need to have defense counsel present. So, look, this guy is sitting there saying, this witness is saying, if I saw him in person, I might be able to identify them. Why didn't they do that?
By the way, not only that, he also says, he talks about the height of the individual. And remember, the point of the photo array is to be able to identify the person's face, right? It's not about their height or their size, it's their face. And so what happens in court? The guy's not standing in court for him to view him. So what is it about him when he's sitting in court in front of this jury on trial for murder allows the witness to now realize that he's the height that he thought he was? There's nothing different now. He's still sitting there, so there's no way to understand how tall he is. Nothing makes sense in terms of this identification.
And you had some racially charged words in this one message that were brought into this case as well.
Well, you have to remember that this is a cross-identification. So we're going from a white individual identifying a black individual, and we know statistically that there's built-in inherent problems with that. On top of it, we also know that when he initially gives his description of the individual, he doesn't describe anything about the specific features of the individuals that are eventually brought into court for this trial.
The defense is saying, look, you've got unknown DNA underneath the victim's nails. The weapon that's presumed to be the murder weapon was allegedly taken from that witness who was there, but the way authorities got it was not through either of these defendants. It was through a third party. So when did they have it, and can the link be made?
Exactly, and the problem also exists, and again, we haven't heard everything, so I don't know that we know everything at this point, and so time will tell. But my understanding is that the witness, the victim's wife, can't identify either of these individuals. And so if the link is simply the stealing of the gun, then I think they're going to have a hard time proving this case beyond a reasonable doubt.
Yeah, that's the standard. We are going to hold them to it. And we will continue with more analysis in the murder case of a U.S. Marine named Jonathan Price. Two particular defendants on trial here, Quincinio Canada and Dewan Mulazim. They are both defendants in this case. They each have separate lawyers, of course, in order to be fair. Two cross-examinations then on each one of the prosecution's witnesses. We're in a bit of a break in this case. We're going to take a look at some of the top crime stories of the day, and we'll be back with more analysis in a moment.
All right. So then you said that they then moved you into, pushed you into the hotel room, put the gun to your head and pushed you to the hotel room.
Welcome back, folks. Again, we're talking about the Jonathan Price murder case out of Lexington, Kentucky. Jonathan Price, 26 years old, was a U.S. Marine when he was shot and killed. He's the victim in this case. There are two defendants being tried for his murder and a number of other related crimes, according to the state's theory of the case. Quincinio Canada is one of the defendants. Dewan Mulazim is the other defendant. Again, this is a death penalty murder case, and the state is saying that there was a second incident several days before the death of that Marine that's linked to the death. They believe the same perpetrators committed both crimes. They're trying to get the victims from a robbery a few days earlier in a hotel room to identify these two defendants as their attackers. And because a gun was stolen from the hotel room that prosecutors believe was used in the murder, they're trying to link this all together through this eyewitness testimony that we've been listening to. But as Julie Rendelman and I have been saying here, we think there's a bit of a hitch that the state's not doing a very good job of making the link through eyewitness testimony and eyewitness identifications, at least not a link beyond a reasonable doubt. So let's continue our review of the testimony. Court is in a bit of a break now in this case. When there's another witness on the stand, we'll take you back there live. And again, you're watching some previous testimony in the murder trial of victim Jonathan Price, 26 years old. He was a U.S. Marine. We have another witness taking the stand right now after a break in court. So Julie Rendelman and I are going to be here listening to this very closely to see where things go. Let's go back to court now live.
Sorry.
Welcome back to the Law and Crime Network, folks. Julie Rendelman, Law and Crime trial analyst, is along with me here as we wrap up the day in the Wallace Bradsher official corruption case. Interesting case, interesting closing argument. Basically, there are a lot of charges here, and we heard that, but it boils down to this guy hiring a neighboring prosecutor's wife, allowing her to get paid without doing any substantial work after one case. That's the core charge here, and you can just sense the bad blood in the room. You've got a prosecutor in another district going after a prosecutor in a more rural county up in north central part of the state. And one of the cooperating witnesses was yet another prosecutor whose wife was the one getting paid without really working. Yeah, it's a mess. What do you make of it?
I think he did a fantastic job. You know, I wasn't that impressed with the actual trial, and I think that the prosecution has some major issues. But I thought that as the evidence was, I thought the prosecutor did an excellent job putting it together for the jury to really understand it. And actually, I understood it better now than I had earlier in this case. I don't know that they made out a case, but I certainly give him some credit for doing a good job.
Yeah, I think that it made a lot more sense at the tail end here, because at this point he was able to use more quotes from the actual testimony. And it was just sort of a bizarre situation because Wallace Bradsher, the defendant in this case, didn't really present a case, and I realize he doesn't have to. It's the state's burden, but
I think he did present a case. I think throughout his entire,
Well, he wasn't calling witnesses.
I understand, but throughout the entire case, he was testifying. I mean, he opened, and his opening was part of his own rendition of what happened.
He was testifying, but he wasn't testifying. He wasn't subjected to any cross-examination.
Which is incredibly troubling. But at the end of the day, the jury got to hear from him without the cross-examination that normally would exist.
Well, look,
and
I mean,
why would he testify if he got to testify throughout this entire case?
Is that a good thing or is it a bad thing? Because he opened his mouth, but did he just dig himself a bigger hole?
I'm not sure. I mean, look, there's always an issue when someone chooses to be their own attorney. He happens to be a pretty decent attorney, I have to say, and I think he did a pretty good job of cross-examination. I think it's always disconcerting when an attorney represents themselves, but again, I think when we look at the actual case, I think there's some questions as to his actual criminal responsibility when it comes to this specific set of facts.
Yeah, bizarre case. Well, look, the bottom line is the jury's going to get it first thing in the morning. We just watched the state prosecutor in Raleigh wrap up closing arguments in that case. So the jury is going to be sent home. It's pretty late in the day here on the East Coast. They're going to get the case at least a chance to deliberate, it looks like, in the morning. Also want to point out to everyone that the murder of the U.S. Marine, that case wrapped up a few minutes ago. The victim, Jonathan Price, 26 years old, was shot and killed. The bullet struck him in the heart. He was shot while he was defending his own wife from a robbery. Two suspects were alleged to have committed the crime. There are two defendants in the case. But as we've been noticing, there seem to be some issues with the way that some of the victims in a related crime seem to be identifying the two defendants in that case. We're going to continue to monitor that one closely. That case is going to pick up tomorrow at 10 o'clock in the morning here on the East Coast, here on Law and Crime. In the meantime, we want to get you caught up on some of the top legal headlines of the day. For that, here's this. That was testimony from a State Bureau of Investigation investigator in the Wallace Bradsher official corruption case out of North Carolina. This is really one of the key parts of the testimony here, as prosecutors try to go after that former elected district attorney on charges that he hired a neighboring district attorney's wife and allowed her to get paid a lot of money for doing no work for quite an extended period of time. Indeed, that wife is said to have really been going to school. Julie Rendelman is here with me now, and Julie's, look, I mean, this is just sort of bad when you get elected officials charged with pulling all this funny business with money, but I think that line of questioning was really key here. It draws both of the defendants in this case, the instant defendant that we're talking about here, Wallace Bradsher, and the neighboring prosecutor who himself was a defendant in his own situation.
Right.
They're not being tried together. He was charged, entered a plea, and then sort of cooperated here. But look, they're trying to get out of this that Wallace Bradsher, this defendant, was telling Cindy Blitzer to sort of vary things up on her time card to make it look like she was working like a normal person and not a robot who punched in right at 8 o'clock and left right at 4 o'clock or whatever. And that sounds like more of a conscious conspiracy to defraud the government, or whatever you want to call it, than not.
Correct.
You following me here?
Yes, I do follow you. I think, and I agree with you that is, to me, consciousness of guilt. Although I'm not sure at the end of the day, his position is that he did give her work, and her position is that he didn't. Remember also that this case doesn't start out with her not having work. The case starts out with her having work to do for him. So originally, my understanding of the case was that the plan was for them to basically switch wives, and the wife would go to nursing school. That's not what happened. The wife was working, and then eventually, at least she says, at some point, he takes the last file from her, and she has no work to do, and then she starts doing the nursing thing. So I'm not sure if certainly not that this crime at least begins at the beginning where the prosecutor initially alleged it did.
Yeah, okay, let's listen to a little bit more of this testimony from this SBI agent who was tasked with interviewing all of the alleged co-conspirators here.
To you.
We're talking about the Wallace Bradsher official corruption case here on the Law and Crime Network. Julie, a couple of quick questions. Cindy Blitzer seems somewhere between complicit and not caring about this, and she's cashing paychecks without working, but she doesn't get charged.
Is that a question or a?
Do you think she should have been?
Of course she should have been charged. I think the focus is on, those individuals that are in public office, because I think that they were hoping to get the bigger fish. I'm not sure that in terms of this case there's necessarily a bigger fish, but that seems to be the reasoning behind charging him and not her.
Well, the jury gets the case in the morning. We will be monitoring the situation here on Law and Crime. A reminder that we are on the air live from at least 9 a.m. until at least 5 p.m. Monday through Friday with live coverage of cases. We'll be back tomorrow then. For now, this is Aaron Keller. Good night.